Good morning. Thank you all for being here. We really appreciate the opportunity to come and speak to you all. So let's go ahead and kick it off and get started. So over the next hour, we are going to do a few things. We're going to lay the groundwork for what the fiduciary duty framework and standards looked like before the N. Ray McDonald's case. We will spend some time talking about McDonald's and its key findings. We'll talk about what that means in terms of the new framework for officer liability going forward, and then also leave you guys with some actionable, tangible best practices for how to deal with this new land rules frame that we're in.
So just let's, starting with the basics here, core duties that officers and directors owe to the corporation. We're going to focus primarily on Delaware today, but I will provide a few anecdotes about Texas law. Generally, Texas will follow, generally Texas follows Delaware's lead in these matters. So Delaware has held that both officers and directors owe a fiduciary duty of care and loyalty to the corporation and its shareholders. Generally, Texas provides for the same core duties of care and loyalty, although Texas courts have recognized the duty of obedience, which is very, very rarely enforced and mostly relates to ultra vires actions. Under the duty of care, executives must handle business affairs with the same level of care and diligence that an ordinary business person would under similar circumstances. They should stay reasonably informed about the business and exercise their professional judgment based on adequate information and advice. Directors and officers must perform their duties with competence and skill and gather and analyze relevant data and facts and seek input from experts and advisors when needed. The duty of care is obviously subject to the business judgment rule, which provides general protection to officers and directors when they're exercising their duties and making decisions, so long as those decisions are made in good faith. Generally, the courts won't second guess them under the duty of care or consider breaches of duty of care. The duty of loyalty, under the duty of loyalty, executives must place corporations' interest above their own and avoid any conflicts of interest or self-dealing. Generally, directors and officers should act with integrity and fairness and refrain from exploiting their position or authority for personal gain or advantage. They should also disclose any potential or actual conflicts of interest to the board and to shareholders and recuse themselves from any decisions or transactions that may involve conflicts. So with the duty of care and duty of loyalty as the kind of the core duties, there's subsidiary or ancillary duties that Delaware courts have recognized. Specifically, the duty of good faith. Under the duty of good faith, executives must act in the best interest of the corporation and not engage in any fraudulent or illegal conduct. The duty of good faith is understood to be a component of the duty of loyalty. It requires executives to be honest and truthful in their dealings with the corporation and stockholders and avoid any actions that will harm or undermine the corporation's reputation or value. For example, executives shouldn't make false or misleading statements or disclosure or conceal material information or manipulate financial results, all of which could result in breaches of the duty of good faith and the duty of loyalty. The duty of disclosure has also been recognized by courts. Executives, under the duty of disclosure, executives must communicate honestly with shareholders and provide full and fair disclosure. The duty of disclosure implicates elements of either or both the duties of care and loyalty. And in a traditional duty of disclosure case, Delaware courts focus on whether the allegedly misrepresentation or omitted information is material to the shareholder action. And then finally, the duty of oversight, which is going to be a large focus of our presentation today. Under the duty of oversight, directors must make a good faith effort to ensure that corporations have implemented proper reporting systems and then appropriately address red flags suggestive of corporate wrongdoing. The oversight duties have been recognized by Delaware courts for over 25 years in the well-known Caremark decisions, and it requires directors to make good faith effort to ensure that effective information and reporting systems exist and then not ignore red flags that are discovered through those reporting systems. Let's go here first. So the Caremark cases, the Caremark test established really the test for imposing liability for breaches of the duty the duty of oversight. And under the Caremark test, it imposes liabilities on directors for failing to properly discharge their duty of oversight under two different prongs. The first prong is really an information system claim, or again, are the systems adequately set up? So a failure to implement any reporting system or controls would result in a breach of the duty of oversight due to a failure of the information system. To make an information systems claim, the board must have consciously failed to make a good faith effort to establish a board-level information and oversight system designed to provide timely and accurate information, and at a minimum address essential and mission-critical legal compliance. The validity of an information system claim does not depend on whether the oversight system was actually effective, but only whether the system existed and was monitored by the board. So the duty of oversight does spawn from the duty of loyalty, right? And so there is a good faith component to it. And under this, I think it's important to recognize that under information system claims, courts courts won't second guess whether the system was an effective system or whether it was good. That would be subject to the business judgment rule, that action, that decision. Rather, an information system claim is simply, was there just no good faith effort to put a system in place? That would result in a breach of duty of loyalty and a breach of the oversight claim. Under the second prong, and again it's an either-or test, the red flags claims, the courts have recognized. The courts refer to the second prong as a red flags claim, whereby the board's information system generated red flags indicating wrongdoing was occurring, but that the directors then failed to respond. The basis for liability requires a demonstration that directors consciously disregarded evidence of red flag wrongdoing or misconduct in bad faith. So again, there's the absence of good faith or bad faith conduct that results in the breach of the duty of oversight, and that the corporate trauma in question must be sufficiently similar to the red flag misconduct such that the board's bad faith proximately caused the trauma. There is, courts have recognized some sort of a proximate cause obligation. So that's the Caremark test that again, Delaware courts articulated over 25 years ago. But in the Caremark case dealt specifically with directors and didn't address the question of whether the duty of oversight extended to officers. However, and there is the Delaware Supreme Court had expressly held in Gantler v. Stevens that officers of Delaware corporations have, quote, the same duties as directors, but it didn't define what those duties were, and so experts and courts felt like there was some ambiguity that existed as to whether the duty of oversight extended to officers. That takes us to McDonald's.
For a long time, Caremark cases were considered to be, and I'm quoting here, the quote, most difficult theory in corporation law upon which a plaintiff might hope to win a judgment. But there were a number of cases that have come up recently that have kind of called this into question, the most recently being McDonald's. And I think we have a summary here on the slides that talks through the very basics, but I do think it is worth some time to just talk through what were the specific facts in the McDonald's case. So David Fairhurst, who was the defendant in McDonald's, was appointed the chief people officer and the head of HR globally at McDonald's. And shortly after taking office, Fairhurst and then CEO Stephen Easterbrook had cultivated what the court in its decision would ultimately call, a boys' club culture. And so some of the different actions that happened and some of the complaints that came up during their tenure were, reports of sexual harassment by David Fairhurst himself. There were numerous other incidents of reports of sexual harassment and misconduct by other employees, including multiple EEOC complaints that came up. There was a 30-city employee walkout where people just walked out of McDonald's just to protest the sexual harassment, misconduct, and other kind of pervasive actions that were going on throughout the organization. There had been inquiries from a U.S. senator about all of the different ongoings at McDonald's, like what was going on there to prompt all of these things. And then there had been class action lawsuits that were alleging a toxic work culture, sexual harassment, retaliation claims, and other misconduct. And so you have a pretty large volume of different kinds of issues that are all in this same space and that were garnering national media attention, not just C-suite or high-level employees, but pervading down to just your normal franchise, McDonald's locations, U.S. senator inquiries. So there was a lot of different ways that these issues seem to be popping up at McDonald's. So you have all of these issues that McDonald's is dealing with on its own in terms of EEOC complaints and all of the lawsuits. But separate from that, there was the stockholder plaintiff action that sued Fairhurst in a derivative action. So separate from everything else, they're saying, we're going to bring a derivative lawsuit saying that apart from all of the other wrongdoing that may or may not have been going on, it was a breach of Fairhurst's duty of oversight to allow these things to happen. So allowing a corporate culture to develop that fostered a toxic workplace environment, permitting sexual harassment and misconduct, engaging in sexual harassment and misconduct himself, and then failing to report misconduct to his superiors or address the HR violations that occurred. So consciously ignoring all of these clear red flags in addition to creating his own red flags through his alleged misconduct. So they're bringing all of this as a derivative Caremark duty of oversight claim. And so Fairhurst filed a motion to dismiss this, saying that the duty of oversight really doesn't extend to corporate officers, but instead was at the board level only. So let's talk a little bit about the court's legal analysis here. So when we have our red flags claims, we're talking about the failure to oversee or this conscious disregard of red flags. And in working through its analysis, the court felt that the director duty of oversight, the rationale for all of that was established back in the original Caremark case, applied similarly here, even though it was with respect to an officer. And there's two main points that we want to emphasize when it comes to this. The court noted that the practical reality is that corporations are run by their officers on a day-to-day basis. It's the officers who are on the ground are in the best position to see these kinds of red flag conduct as they arise. The board is meeting regularly. They've got quarterly, maybe more frequent board meetings, but they're not the ones who are in the office day in, day out seeing what's going on, whereas the officers are. So as these red flags come up throughout the organization, it's really the officers who are right there on the scene to see what's happening. Also, since officers are the ones who generate and collate information that then gets passed up to the board of directors to help them fulfill their duties, it's really officers that need to be making this good faith effort to ensure that these information systems are in place and are working appropriately. So a lot of the court's thinking was, okay, Caremark established these duties of directors and they have this oversight claim, but to actually implement that and make it effective, it really does need to extend down to the officers who are, boots on the ground making it all happen. So then the key finding of the McDonald's case is that the duty of oversight is expanded to officers. And having considered that it's going to apply to officers, the court wanted to look at the plaintiff's claims here specifically. One thing to note was that this was at the pleading stage for the motion to dismiss. So at the time that the court was going through their analysis, they did have to assume that all the plaintiff's facts were true as stated. But there were a couple of key things that they focused on when looking at the pleadings. One was that the plaintiffs had pleaded, sorry, a little tongue twister there. The plaintiffs had pleaded sufficient facts to be able to claim breach of duty of oversight against Fairhurst for both his own duty of misconduct as well as his conscious disregard of the ongoing and serious issues that were taking place at McDonald's. So when it comes to his own misconduct, the court noted that, should they be true, these allegations of sexual harassment and misconduct are bad faith actions that are committed for an improper purpose that are not in the best interest of the company. So his own actions would be a breach of his duty of oversight. Second, the conscious disregard. His failure to take action was one thing, but also they noted that that was reasonable to infer that given his own actions, he would take a blind eye to the actions of others. And so they saw that as a failure to fulfill a duty of oversight. So it's really interesting seeing how they thought about this, because when you think about oversight, you might not necessarily be thinking about your own actions, but the court said, no, that is going to fall within the duty of oversight here for the reasons that we just discussed. Now, it is important to note that the court focused on some limitations here when we're thinking about what is the duty of oversight at the board level versus the officer level. So at the board level, their oversight duties are regarding the whole corporation. They have oversight responsibility when it comes throughout the organization, all of the goings on, and so that's a pretty broad scope. For an officer, that may or may not be the case, and it sort of depends on what the officer's duties are. If you think about who the officers could be, so if you got your CEO, they're probably going to have a pretty broad, very similar to the board, and in fact you often do have CEOs that sit on the board themselves. So their oversight duty would be pretty wide-ranging throughout the organization. If you have an officer that has maybe a much more targeted role, like chief legal officer, it's reasonable to assume that their oversight duty might be more targeted within their kind of realm of expertise and the realm of their duties. And so those are kind of things that will need to be thought about as we go forward, and we'll talk about more in the context or the rest of this presentation for what that means in terms of fulfilling the duty of oversight. I think it's also, I'll point out now, this also could be very different depending on the type of organization that we're talking about. So if it is a very large international organization like a McDonald's, others, you might have officers that just have a lot of officers, first of all, and they might have very streamlined and very, what's the word I'm trying to say? Like clearly delineated duties. But if you're thinking about this in the context of maybe it's an early startup company, you've got a young company where shift a little bit. Maybe they are chief operations officer, but they're really in the weeds on a lot of other functions. It'll be important to think about that whenever we're talking about what is the officer's scope of liability, because that's a really different situation. Even if you have this one title, what are your actual duties? What is the role that you are actually playing within the organization? So thinking about that thoughtfully as you think through these issues will be really important. And obviously it's not a one-size-fits-all answer for all the different companies out there. So along those same lines, other questions come out on kind of what level of officers. You've got this McDonald's case that says, okay, we're going to extend the duty of oversight to corporate officers as well. But what exactly does that mean? Who is an officer? If you look at this, and we have the quote here because I think it's important, if you look at the language from the McDonald's opinion, it says the officers are optimally positioned to identify red flags and either address them or report upward to, quote, senior officers or the board. So that means that you're not necessarily just talking about your top C-suite. That could extend to lower level officers who also have their duty to report upward and then on to the board. The Delaware General Corporation Law defines officer as officers with titles and duties as shall be stated in the bylaws or in a resolution of the board. And in Walt Disney, there was a bright line test where officers and directors become fiduciaries when they're, quote, officially installed and receive the formal investiture of authority that accompanies such office and directorship. So it would seem that if you're going to piece all of these different angles together, that what that would mean is that the officers that are specified in the bylaws or appointed by a board resolution might be your quote-unquote officers. But that hasn't been tested, that hasn't been found. It's a good way to think about it, but I think it's also really important, going back to my earlier point, that you're thinking about what makes sense in the context of your specific organization. And I do want to just reiterate one more time that, like we talked about on the prior slide, officers need to be aware that their own misconduct, and not just their failure to monitor and address red flags, can give a rise to a claim for a breach of the duty of oversight against them.
Thanks, sir. So, I think it's important, just before we move on quickly, to talk about, like, McDonald's was an interesting case, but it involved bad actors. right? And so while it was an extension of the duty of oversight to officers, it still is a breach of a duty of loyalty claim, which is a high bar, right? There still has to be a showing of bad faith. And so while there's been an increase in these breach of duty of oversight claims recently, and Delaware courts have even allowed the claims to proceed, and past the motion to dismiss phase, as we've seen in McDonald's. Typically, they do. These are the exceptions, not the where you really have kind of bad actors involved. As an example, there's a second case, right, against the directors, a second derivative lawsuit against the directors that was dismissed at the motion to dismiss phase, because the court said, look, there was systems in place, and then the board did learn of these actions of the CEO and of the head of HR, and they were taking steps to try and alleviate those concerns, dating back to like 2019. Were those steps effective? Obviously not. But again, that gets back to the business judgment rule, and they weren't going to second guess those decisions that were made by the board. Specifically, there was a couple decisions I think that the court looked at in that case. One of them was the decision back in 2019 or 2020, when allegations against the head of HR first came to light, that they didn't terminate him at that time. They basically didn't. They made an exception to their policy that was in place. Right. And then there was a second decision, which was to when they ultimately terminated the CEO due to similar claims, they entered into a severance agreement with him. So they didn't terminate him for cause. So that decision not to terminate him for cause at that time was something that the courts looked at and said, look, we're not going to second guess that. So I think, again, while this is an extension of the duty of oversight and it's an extension to officers, we still need to take that into context with these are still breach of duty of loyalty claims, which it has to involve bad faith.
Right.
So with that in mind, what are the legal implications of breaching fiduciary duties? Just generally at a high level, executives may face personal liability for monetary damages, injunctive relief, disgorgement, rescission, or other remedies. There is also the possibility of criminal charges or civil penalties. So one thing we'll also talk about a little bit later on is exculpation and the extension of exculpation in Delaware to officers, which would help with the personal liability, but does not apply in the context of breach of duty of loyalty claims or specifically these Caremark claims. So not directly on point, but it is something that we're seeing a lot of corporations look at. So then focusing on some kind of best practices or things for the board and for officers to be thinking about going forward. Coming out of the McDonald's case specifically, we think that corporations should make sure that they implement policies on officer oversight obligations, and make sure that document how officers should document their knowledge of and responses to red flags, including to the board. This was something that was kind of lacking in the McDonald's case, and certainly something that is very important, not only to have the policies in place, but to have documentation around the reporting up, what discussions and actions may have been taken in response to red flags. Corporations should ensure that there are appropriate anti-harassment and anti-discrimination policies, practices, and trainings in reporting, investigation, and compliance policies and systems in place, and that those policies and practices are periodically reviewed. This could include, for example, creating a hotline for employee complaints, conducting training for HR personnel on proper investigation procedures and best practices, and conducting separate trainings for supervisors on their reporting obligations. Again, it's important that we document all related actions, as litigation actions involving an alleged breach of the duty of oversight are often preceded by Section 220 books and records requests under Delaware law. And the corporation should be able to produce ample evidence in response to these books and records requests that shows that the officers or the board made good faith efforts to properly execute on their duty of oversight and document that the oversight system, one, that the system was in place and it was established, and that the officers and the board reviewed and discussed the compliance issues and followed up on any red flags and addressed them as needed or as they felt was appropriate.
And one other point on that is I think that for a long time, conventional wisdom when it came to thinking about these 220 requests was that when you're documenting your minutes, sometimes, particularly around sensitive issues, you might want to avoid too much detail because, the implication being that it's discoverable and you don't want there to be too much there. But this is a departure from that, and I think that over time it has become better practice to make sure that you are recording all of this and providing this very clear record in the minutes. And part of the reason for that is because, with Delaware 220 claims, if you are able to establish via your formal board records, formal communications, minutes, all of that there was a clear discussion of the relevant issue, that it was talked about, that it was thought through, that decisions were made. Again, going back to business judgment rule, whether they were the right decisions or the right conclusions is a different issue. But the fact that you kind of went through and followed the process, that can really be helpful because to the extent that you don't show that, that might mean that it opens the door for plaintiffs to then say, okay, well now I want to look at emails because what you have in your formal records really isn't sufficient to show that you considered these issues strongly. And so, our guidance that we're providing to our clients is, okay, scratch the kind of too summary approach when it comes to issues like this in your minutes and really make sure that you're walking through the thought process, the analysis, and the decision-making here so that you can try to, as best you can, avoid that secondary request for follow-up, email-type discovery.
Right. So the officers should also focus on their compliance programs and internal processes. We suggest that officers, in cooperation with the board, ensure the company has implemented systems for information reporting and evaluation, and ensure that those systems are reasonable for the organization's needs and for the officer's role in the organization. Again, as Sarah said earlier, there really is no one-size-fits-all approach. These policies and procedures are going to be different for each organization, perhaps even each organization within the same industry. And I think each officer should really focus on his or her role and responsibilities in the organization, really identify, I think it's, incumbent on the officer, this is their duty of oversight now as has been extended by the Delaware courts. And so it's going to be incumbent on the officer to identify the essential and mission critical compliance with laws or regulatory mandates facing the company that are within the scope of that officer's authority. And then establish those monitoring systems that the officer feels are necessary in connection with, in conjunction with the board or its supervisors to bring the information to not only the officer's attention, but then the officer can report those up to its supervisor or to the board if necessary.
So I think one other thing that we want to focus on here or just kind of mention to you all is this mission critical compliance language. There have been other Delaware cases prior to McDonald's that established this mission critical language. So you may have read about the Bluebell ice cream case where there was the derivative stockholder litigation brought due to the failure of the board to fulfill its duty of oversight relating to all of the listeria outbreaks that happened. There was a similar case that was brought against Boeing relating to plane crashes for one of their new planes. And in those cases, it kind of developed, it was like, okay, food safety is mission critical to someone who provides ice cream. Plane safety, passenger safety, that is mission critical to someone who is a plant manufacturer. Like those things kind of make sense in terms of how are we thinking about mission critical. But what was interesting is that in the McDonald's case, there wasn't any discussion of mission critical. And if you're thinking about, toxic workplace, all of that kind of stuff, is the workplace environment something that if you're looking at this mission critical language, are you thinking about that as something as being mission critical to the operations? Like, talking about sourcing beef, I think that makes sense as being something that people would think that is mission critical to McDonald's operations. But here we have a case where it's not something that relates to that. And so that could leave officers thinking, okay, well, if I'm thinking about what are the key things for my organization, I've got some cases that are talking about mission critical. We've got this McDonald's case that debatable whether or not you would consider that to be mission critical. How should I be thinking about these things going forward? And I think that one area that we think makes a lot of sense is just, again, you'll hear it, you've heard it, ESG. It seems like an area where that is where so much focus is happening. That's where plaintiffs are looking. That's what everyone is thinking and talking about. So, thinking about what are really the key functions within your organization, really be thinking about ESG topics. And I would also add to that probably cybersecurity data privacy is a hot area. And it's a focus for the SEC and regulators. And so I think that those are some practical areas to be thinking about and a good way to think about this going forward, absent. I just want to avoid the implication that you can tunnel focus on just what are my mission critical tasks.
Yeah, that's a great point. In terms of the questions being raised around whether the mission critical component continues to apply given the McDonald's case, I definitely think if you're thinking about it, though, that there probably is some component there that still does apply. But what would be the mission critical roles in the organization, right? It's clearly probably the chief legal officer, the chief compliance officer. It's clearly the CFO and the chief accounting officer and the financial components there. In McDonald's, you obviously have an example of HR, and they basically extended that to, all employees are mission critical to the organization, to every organization, right? And I think Sarah brings up a great point around ESG, others, cybersecurity, other areas of the organization where you may have officers who are in charge of those functions and who may need to put in place specific, policies and procedures to identify red flags for noncompliance and then report those up. And those may be less obvious, I think, than the chief compliance officer role, right? But there's certainly many organizations are putting in place, a head of ESG or head of HSE reporting and obligations, and so similar roles.
So another kind of best practice moving forward is going to be to establish really clear definitions of officer duties and responsibilities. So we talked before about some of the kind of open questions about what might make sense, what are the duties of different officers in different kinds of organizations, different types of officers. We also noted that we think that it's probably going to be the case that you're going to have to be dealing with these issues for sure for officers that are specified in either your corporate bylaws or adopted by resolution. But it's important from a larger level too that the board is going to be implementing policies requiring documentation that very clearly identify who does our organization consider to be an officer? And what are the duties and responsibilities of that officer? Scoping, limitations, making sure that you're as best as you possibly can, providing a very clear framework that the board understands who the officers are and what their duties are, and then the officer understands what are my responsibilities and duties, and then also reporting lines and accountability structures. That way, as you're going forward, you can understand when a red flag comes up, who does that responsibility lie with? How should it get reported up? And you can make sure that those things are all clear. So taking the extra time to establish that framework and clarify that framework to the extent that there is kind of some murkiness right now, I think will be really helpful going forward in dealing with these kinds of issues. It's also going to be important for employment agreements to define the officer's responsibilities and duties, since, as we've talked about, what those are will have implications for their oversight duties. So let's talk a little bit about reporting up. We mentioned earlier how the courts are thinking about officers as the day-to-day managers of the corporations. They're the ones who have to make the good faith effort to ensure that these information systems are in place, that are working, they're receiving the information on a timely basis, and that way they can provide it up to the directors and help them fulfill their own duties. As agents, officers owe the duty to disclose. We talked about that duty of disclosure earlier. Relevant information that they as officers know that may affect the decisions of their principals and the board. And even though we've talked a lot about defining roles and making sure that officers understand this is sort of the scope of my oversight duty, that doesn't mean that you can turn a blind eye to sufficiently prominent or particularly egregious red flags that are outside of your scope. So if you're seeing clear violations of the company's policy, if you're seeing clear violations of law, I mean, just obvious things, even if it's like outside of your scope, you can't say, that's not me, that's someone else's function. If you see it, you really do have that obligation to report it up to make sure that those issues are getting handled, timely and effectively by the board and those who might have a broader oversight than your own.
The other thing I think is important to focus on here, and it's kind of related to reporting up as well, is that corporations should really pay close attention to the manner in which they conduct internal investigations. So in the McDonald's case, there was a focus. Well, in the director derivative litigation case, there was a focus on the internal investigation into alleged sexual harassment by the executives, and it was really a very short and limited investigation, and the court noted that. And so I think that to the extent you can, once there is the reporting up, and then there's an investigation into the actions, and making sure that it's a broad, fulsome, expansive, internal investigation, maybe engaging outside advisors if necessary. And documenting that process is going to be also very important, as we mentioned earlier. I mentioned earlier about exculpation, and one of the things that I think a lot of corporations are considering, and a lot of officers are maybe considering who are at corporations, Delaware corporations, is the expansion of exculpation provisions in charters to officers. In fact, the McDonald's court even observed that unlike directors, officers are often not protected by exculpation provisions in their certificates of incorporation, which, as I said earlier, the exculpation provisions generally limit a liability for breaches of the duty of care. They don't apply to breaches of the duty of loyalty, for which we're talking about here mostly with the duty of oversight claims. But the court suggested that corporations should consider adopting these exculpation provisions, and we believe that many corporations are already doing that, and will continue to do that over the coming years, as due to the recent amendments to Section 102b7 in August of 2022, where now Delaware corporations are permitted to include exculpation provisions in their certificate of incorporations, which again would eliminate the personal liability of a director or an officer. So it expanded the provision from just directors to officers, with certain exceptions. Those exceptions include caremark claims, breaches of duty of loyalty, bad faith or intentional misconduct, and then improper personal benefits again. So again, broadly speaking, exculpation provisions apply to breach of the duty of care. There is one difference, though, between the exculpation provisions that would apply for officers versus directors. For officers, they are limited to direct claims brought by stockholders, not claims brought by the board of directors or derivative claims. So the board can still bring derivative claims against officers, and those would not be subject to exculpation under the new 102b7.
That's right.
Obviously, we also suggest that corporations evaluate the provisions in their employment agreements, in any indemnification provisions or separate indemnity agreements. It's a good practice to do this anyway, but in light of the expansion of the duty of oversight, the possibility of increased litigation or claims being brought, corporations should make sure that their existing agreements align with their expectations in terms of when an employee would and would not be indemnified. Generally, there's not going to be indemnification for breaches of the duty of loyalty, but we would want to make sure that those provisions are in place and are in line with those expectations. And understand the conditions for indemnification as well, and the D&O and also the D&O policies, and where those how that applies to these types of claims and what protections or limitations officers and directors will have there.
I think that's the end of our slide deck. So, just kind of some last thoughts are just coming out of this, there is this increased scope. There is this, new duty of oversight that is applying to officers. There's not perfect answers yet, and there's still a lot of questions in terms of how it's going to apply. And, I'm sure there will be further cases that show up, so, watch the space. But there are some things that you can do. Most importantly, just reevaluating, what does our framework look like right now? How do our employment agreements work? Like, does all of this hang together correctly given this new expanded scope of liability that the court has clarified? And so taking the time to have that exercise and just say, this is how it works for us. This is what we think makes sense. Do we need to make adjustments? Or is it all relatively clear? Is it not needed? But it does make sense, in our opinion, to go through and have that exercise, have those conversations, and make sure that everyone is comfortable with where all of this has landed for you. And with that, I think we will open it up for questions.
Yeah, and one thing I'll also add is that in Texas, so duty of oversight does apply in Texas. Texas courts have recognized this duty of oversight. To my knowledge, there's not a specific case detailing the duty of oversight as it applies to officers, but Texas courts have expressly said that they have followed Delaware courts' lead in this area previously, citing Caremark cases and kind of other similar cases. And so the expectation is that the same rules would apply here in Texas.
Any questions? Mike.
Good morning. I've had the situation where people come to me saying, I have a question, and I immediately go to, are you asking the question as a friend or as an officer? Because there's two different responsibilities there. As a friend, I feel there's an obligation to the person coming in on a personal level, but at the same time, I forewarn them in a way that if this bit goes or crosses the line, so this sounds like a whole new dilemma here with the responsibilities as set forth by the McDonald's case. What's your opinion?
I think that your advice to your friends who are coming to you for questions is good. I think that you don't really know what's going to come out of their mouth until it comes, right? And as an officer of the organization, you do have this duty. As things become aware to you, if someone comes to you in confidence, what does that mean? If they're your employee, if they're your direct report, they come to you to talk about an issue and it turns out that it's a pretty significant issue, you do have this duty to report upwards when it comes to things like that. So, personally, I would think that your approach is exactly right, that you need to let people know that, hey, I'm here to help you talk through issues, but I also have a role that I have to play in this organization and need to make sure that I'm, reporting upwards to the extent that I need to. And it can be really tough to navigate that whenever you're close friends with, your colleagues, people who you've worked with a long time, and you want to be able to support. But I think that your approach is exactly right. John, do you have anything to add to that?
Yeah, I agree. As an officer, you have duties to the corporation, and I think to the extent the conversation with a colleague who is also a friend is truly personal and doesn't relate to the business and the corporation, that's one thing. But to the extent there's overlap there needs to be a recognition, of your roles and responsibilities with the organization, inside the workplace. That's a whole nother, I feel like a whole nother presentation around, the roles of the GC and obligations of to the corporation versus where those duties lie. So.
Yeah.
Any other questions?
What about folks below the officer level, like managing directors that sometimes have just as much command and control as officers? Do you see that being pushed down further?
I didn't hear the question.
I'm sorry, can you repeat the question?
Sure. What about folks below the officer level, like managing directors and such that have just as much command and control sometimes?
Yeah, I think that that's tough because if you think about something like, if you think about something where people are doled out an officer title, even if they're not functionally serving in sort of how we think about the officer role, I think that that's one of those points where as an organization you need to have a conscious decision on how are we going to treat those people. If they don't have like a real decision-making strategy, leadership function, do we want to consider those people to be officers of the corporation? How does their title play into that? And I think that again, no one-size-fits-all approach, but I think that if you have someone who maybe has an officer-type title but isn't truly serving in that capacity, just having the conscious decision in the documentation will be really helpful in supporting those kinds of issues should they come up at that level. Would you agree with that?
Yeah, absolutely. But I think, just in the context of what we were talking about today, and in the McDonald's case, it admittedly was a little unclear in terms of what officers they were talking about, right? I think if you look at Delaware statutes, the idea is that ideally it would just be the kind of senior executives or executives that are identified and approved by the board, right? At least in terms of who would owe these fiduciary duties and therefore be subject to derivative claims from shareholders. And therefore otherwise, require protections, et cetera, against potential liability for claims without merit. But I think regardless, one of the things that we feel like is important is that those that are below those senior officers, the managing directors or directors, there are systems in place that require them to report up, provide information to the senior officers so that they can identify those red flags and then take action, right? I think that's what's really jumps out of the case to me is really it while the duties may lie at the most senior level, ideally, that duty includes the requirement to have the policies in place so that you have the reporting up and identify those red flags so you can take action.
Yeah.
Anyone else? Sorry. I'll throw one out. Sarah, you mentioned, or you spent some time talking about the mission critical analysis. Mm-hmm. If I understood correctly, you're saying that anything that impacts culture, so in this particular example for McDonald's, because of the sexual harassment culture, it became mission critical because it created a toxic workplace. Is that correct? Like you mentioned the Bluebell and Hysteria,
So I think a couple of things. I think that courts might be backing away a little bit from the pure mission critical language that they had adopted in some of the prior cases. But I didn't get into this level when we were talking about McDonald's, but the McDonald's board had hired in outside consultants to identify what are our key areas of risk, where do we need to be focusing as an organization. And when those consultants came in, they actually identified workplace culture as a tier 2 risk. So there were certain tier 1 things that they were dealing with, and this was labeled a tier 2. So what that meant in the context of this report was it's something that isn't tier 1 right now, but if left untreated could become tier 1. I think that the reason that this McDonald's case rose to the level that it did and it kind of got to this finding had to do with the fact that it was an ESG matter and the issues were clearly so pervasive. Just this kind of hate to use the word, but the flagrancy of the issues that they were going on with. I think that played a big role in why the court went this way on McDonald's.
Yeah, there were bad actors.
Bad actors.
Right. I think that gets back to that at the end of the day, that while the court took this opportunity to clearly spell out and expand, the duty of oversight to officers, it gets back to, they kind of glossed over maybe the mission critical component.
Right.
Perhaps for two reasons. One, HR employees, and they felt like employees are just mission critical to every organization and it was just a given. Mm-hmm. Or, two, it was just such egregious activity that they didn't need to get into that.
Right. Which is why in trying to think about, okay, what does that mean for my organization? What we would encourage you to do is think about not think too narrowly about what are my mission critical tasks, but keep in mind things that are kind of top of everyone's mind right now in terms of corporate America and culture. So like the ESG, the data privacy, cybersecurity, all of those things.
Thank you.